October. The warrant of arrest, the J50, bearing the name Kelly Khumalo, was not part of the documents that were...
No, it wasn't, my lord. That statement was made in November, and the application for J50 for Kelly Khumalo was made at that stage, my lord, November 2020.
Le ncwadi ebe ucela ukugunyaza ukuboshwa kuka Kelly Khumalo beyikade ikhona na ngalesa sikhathi wenza le statement cha le statement isiyenziwe ngo-2020 le ncwadi yona iyenziwe ngemva kwalokho.
Thank you. May I proceed to establish from your brigadier in terms of the discretion. Did you take any discretion to stay or not to apply for a warrant of arrest against Kelly Khumalo?
No, I did not, my lord. As I indicated, it was this case, this matter was a prosecutorial driven investigation. Now, prior to the application of the warrants that was made on the 23rd of October 2020, I've indicated in my evidence in chief that I made presentations, or not presentation, a memorandum to the DPP, where the not-hopping one, where I indicated all the evidence that we have on all implicated people, including Ms. Kelly Khumalo. She is there. A decision was taken at that time that these are the people that must be indicted, and that is accused 1 to 5. I cannot disclose further details in terms of our discussion with the NPA, my lord, but there were certain things that needed to be looked into insofar as Ms. Kelly Khumalo. Then the following month, when we have covered some more grounds than then, that's when now I made a presentation again to say this is where we are and we're making this proposal.
When brigadier uye wathatha isinqumo noma wacabanga ngokuthi mhlawumbe le ncwadi le egunyaza ukuthi uKelly Khumalo aboshwe ingahle iqhubekiswe na uthi cha angizange mina nyenze kanjalo, mina bengikade ngiphenya lelicala kulibele kuphenywa yonke into futhi ithema kuqedwa kulayi ukuthi mina ngiyengaya kubaphathi babashushisi ngiyofaka isicelo sokuthi nabo abamangalelwa ekuthi mina nginabo nginokufakazi ngakubo ukubandakanisa naye uKelly Khumalo la ukuthi ke bona abashushisi baye bathi naba abantu ekuthi bakwamele bashushiswe okwamanje njengoba kungakaqedwa uphenyo yena ubrigadier akazange athi abushushiswe labantu uKelly Khumalo yena aye.
In the light of the fact that of the evidence that accused number 2 made 2 confessions, one before Colonel Rapadu and the other one before Magistrate Mrs. Cronje, was it also your discretion that it was not necessary for accused number 1 to be taken before another magistrate after he has made a confession or the alleged confession before Colonel Mboto?
No, my lord. I think I've explained this part. So the magistrate part for accused number 2 came as a result of a 105A communication between ourselves and the state prosecutors. That's how it kicked in. I was satisfied with the confession that was made because it missed the merit. It's a commission officer, he's a justice of the peace, there was a confession. Subsequent to us engaging with the attorney for accused number 2, and in discussion with the plea bargaining with the state, it flowed from them, and then there was this confession for accused number 2, which was not the case with accused number 1.
Awuzange ke ucabanga ukuthi ummangalelo oqala naye bekwamele ayiswe ayoyenza ayogunyuluka phambi komantshi njengommangalelo wesibili. Uthi ngemva kokuthi bese sesikhulumisene nabashushisi kulayi ukuthi ummangalelo wesibili bese sesiyesathatha kwaxoxwa futhi njengoba bekayenze nalesi sicelo sokuthi yena kube ufakazi kugcine seyikuthi unikwa isigwebo esingaphansi. Ngemva kwalokho kula ukuthi siye sathi sanelisekile ukuthi umangalelwa uqedile ugunyulukile bese kwathathwa ke nalesiya sinqumo sabona ukuthi naso umangalelwa woqala ubekade egunyuluke kumuntu onayo imvume yokuthi angalalela istatement esifana nazo lezo lo muntu ngikhuluma ngaye uKenneth.
Thank you, Brigadier. I'm well aware that such an engagement was done between the representative of accused number 2, as you say. But I just want to get into the point of accused number 2 being represented. The evidence, according to the state, is that the said person on the 24th of June 2020 was present when accused number 2 make a confession or the alleged confession. Secondly, the evidence that the state has is that the same attorney also participated in the plea bargaining agreement, and to the extent that such a decision or such a plea bargaining agreement was not concluded or finalized.
So
the question.
must I comment?
Yes,
What is the
I
question?
just wanted to ask a question. Throughout the involvement of Mr. Mjiako, the alleged Mr. Mjiako, firstly, before I proceed with the question, was the agreement concluded, the plea bargaining agreement, in terms of section 105, capital letter A?
My lord, yes, it was. So there was. It was not only Mr. Mjiako when the 105 capital A was involved. There was also another advocate who came on board. I mean, those are the issues that are because they form part of the discussions. And there was proposals and affirmations of standing with the confessions that were made by accused to the magistrate and Lieutenant Colonel Rapad. And the proposal of him testifying against his co-accused for a specific sentence, which we were of the view as the state that we are not happy with that sentence. The deadlock, it was concluded, because there's a formal communication, it was concluded the difference was on the proposed sentence from the defense side in terms of what accused 2 is prepared to do in relation. There was a specific sentence that is sent to us and said, I'm prepared to serve this sentence and in this manner, and then in return, I will testify against my co-accused, etc., etc. So it was formal and finalized.
Yebo bekuye kwaqedwa inkulumo phakathi kwabashushisi amaphoyisa nommeli ummeli uMjiako akusiyena yedwa kona omunye ummeli into bengikade ngingafuni ukuyiveza kodwa ngoba seyabuzwa nakho ke kwamele ngiyiveze ukuthi siye sahlulana nje uma sesekufika kwisigwebo lesi umangalelo wesibini wayekade ethe yena uzimisela ukuthi angasiya ejele noma ahlale endaweni ethize noma ahlale kanjani leso sigwebo leso kula siye sahlukana khona futhi umangalelo wesibini yena bekathe uzimisela ukuthi angayenza leso sigwebo bese uyabuya abe ufakazi ngombuso afakaze kulento ukuthi abamangalelwa abane laba abanye bayenzile kulo lecala.
My lord, it's also prudent to mention that in this communication, I remember one document, he clearly admits that he stands with the 2 confessions that he made. And these discussions, my lord, were taking place after the matter was enrolled. It was not discussions that took place before the first appearance on the 27th of October 2020. While the matter was going on, after the first appearance, second appearance, those discussions were taking place so that one can decide where he must be placed. That is why at some stage the court would have seen that in the occurrence book he spent also a lot of time in police stations, because there was these discussions, and it was put by I think on the first appearance, the request was made by him in court. Mr. Khumalo was there for accused two to be kept at the police station. It was because there were these part of discussions that was taking place confidentially.
Futhi le inkulumo lezi ziyenzakele leli cala liselingenile enkantolo, akusukuthi beqalwa ukuthi abamangalelwa bavele enkantolo bese sekulibele bevile enkantolo. Ingakho ummangalelo wesibini yena uNtanzi wayelibele ebekwe esitokisini samaphoyisa isikhathi esiningi, futhi uthi nommeli umshololo wayekade ekhona ngalesikhathi uNtanzi eyenza leso sicelo. Akusukuthi bavele bayicabangela ukuthi uNtanzi yena angafakwa nabanye esitokisini kungenxa yokuthi bekusakhulumisanwa.
Thank you. Once again, we just want to sound a word of caution to my learned friend that in terms of section 105A, if there's a proposal, a 105A proposal, if it falls flat, reference may not be made to it in any other manner, but if he elects to elicit that information, he does so at his own peril.
Umshutshisi ucela ukucebisa ummeli omngomezulu ukuthi le mvumelwano leyana noma le yankulumo akusiyinto ukuthi kungahle kudingidwe ngayo, kodwa uma ingabe uyafuna ukuqhubeka lapho angahle ahlabele emgaqo.
Thank you, my lord. I'm not intending to get into the gist of.
Oh, you're not disputing it.
Now,
It's one matter to not intending to get into the gist of it.
not that I'm not disputing
Okay,
it. Not that I'm not disputing it. My, in fact, I'm concerned about the representative, the legal representative, or the mandate that Mr. Mjiako alleged to have been given by accused number 2 to represent him. That, according to you, Brigadier, is there any power of attorney that was furnished by Mr. Mjiako?
My lord, I don't think I have authority to ask him to show me the power of attorney. When I met him on the 23rd, the first time, 23rd of June, after I was informed that there's a gentleman who is saying he's an attorney for accused number 2. I don't know how they communicated. I went there, my instruction, and I've said this in evidence in chief, my lord, that I said they must allow him, despite the COVID regulation, because it was a legal visit. I arrived, he identified himself, gave me proof from the LPC, which I verified, and later we just get a confirmation from people. Other than that, my lord, I don't think I could have taken it any further. I don't think I have authority to say, give me the power of attorney. All I wanted to know was to confirm when I arrived, if he was legally, if he was indeed an attorney, that was confirmed. And subsequent to the proceeding that followed, I was convinced he was an attorney, my lord, because like I said, he appeared numerous times on this matter from the time of its inception, and subsequently in Pukeng as well, my lord. And then thirdly, the discussions in terms of section 105 with the state and with the advocate that he appointed at that time, my lord.
You don't want to disclose the advocate?
I know the surname was Butelezi, my lord. I remember the surname was advocate Butelezi.
Okay.
Uthi ke wena ke brigadier ubona ukuthi ummeli lo umjiyakho wayekade enalo ilungelo na lokumela ummangalelo wesibini. Uthi mina anginalo lelo gunya lokuthi ngimbuza ukuthi unalo ilungelo. Ngitshelwe ukuthi kuthwa uthi uzomela uNtanzi ngathi abamvumele ngenxa yokuthi bekunale labhubhane lo COVID-19, ngathi abamvumele. Nami the mangifika wanginika ke incwadi ebonisayo ukuthi buya khona kubaphathi bama lawyer, waphinda futhi ngambona futhi nasenkantolo kulo leli cala leli, futhi nasePhukeni ngambona. Nangokho bekungasuyena yedwa lo munye owesibini angilazi igama lakhe ngazi nje isibongo sakhe kwakade kungowakabuthelezi.
Lastly, my lord, also I've indicated that on the 23rd, as I was approaching when I arrived at the police station, it is accused number 2 who first stood up and said, "This is my attorney," to me. Secondly, on the first appearance, because I was there, it was asked, accused 2 confirmed that he, Mr. Mjiako, is his legal representative. It's on record, it was televised, my lord, it's there.
Futhi ke enye into yesibili esemqoka uthi ithe yena mayifika lapha esiphoyiseni kulayo ukuthi umangalelo wesibili uyena watshela ubrigadier ukuthi nawu ummeli wami futhi nayiqala uma lingena enkantolo belikade liboniswa nakumabona kude umangalelo wesibili washo nakhona ukuthi ummeli wakhe uyena uMjiyako.
Sir Brigadier, with due respect, if the court were to grant us leave to produce the clip, accused number 2, you were present, and he instructed me that when he was addressing the magistrate to the effect that I don't want this attorney, Mr. Mjiako responded, the presiding officer said, "I can't listen to you if you are represented." Did you observe that, sir?
Not only, but that's not true, my lord. I was there, that's not true. Like I said, Mr. Mcholo was there, the state advocate was there, number of people were there, journalists were there. There is no way where accused 2 said in that the first appearance that he does not want Mr. Mjiako. That's absolutely not true. That's why even the request of where he must be incarcerated came through the attorney, Mr. Mjiako. And accused 2 moved with us for that incarceration during that time. So that is not correct, my lord.
Manje ke uthi ummeli uMngomezulu brigadier akusiqiniso lento ewuyishoyo ngoba ngalesa sikhathi ummangalelwa evela enkantolo uye waphakamisa isandla wathi yena akafuni uMjiyako kodwa uMantshi wathi ngeke ngikulalele wena Ntanzi ngoba unommeli. Nangokho ummangalelwa bese sekathe yena akamfuni uMjiyako futhi naye ummeli uMjiyako uyena owaqhubeka efaka nalesi sicelo sokuthi ummangalelwa athathwe ahlaliswe endaweni yakhe eyedwa futhi uthi bebakhona aba umshushisi wayekhona uyaphinda futhi uthi nommeli uMshololo wayekade ekhona neintatheli zazikhona ngalelo langa. Ayikho lento yokuthi uMantshi wathi ngeke alalele uNtanzi ngoba enommeli uyakuchitha lokho ubrigadier.
Mr. Mngomezulu, I hear you saying you're thinking while there, no. Maybe it would be necessary for the clip to be played. Did I hear you correctly, sir?
That's correct, my lord.
No, but the law, does the law allow it? Remember, those proceedings were nullified. Now the question is, are you saying the proceedings in the regional court are not part and parcel of the subsequent proceedings which inured before my colleague?
My lord,
just listen to me, because
yes,
you can think it's something simple. So if the proceedings start from the regional court,
yes,
and then they are postponed in terms of section 72C to the High Court, those are the same proceedings. And when subsequently there's a plea and the proceedings before what's my colleague's name? Right. Sorry, yeah, thanks. Mr. Judge Maumela, they proceed. And subsequently, through an order of this court, before I was appointed to take over the matter, they are nullified. Are you with me?
I'm with you, my lord.
Can you have the right to think aloud, like you are thinking, to say that tape of the first appearance in the regional court must be played? I don't think so. Me.
May I
What
be?
do you think?
May I be afforded an opportunity to
To check the law.
check the law, my lord? Then I'll make proper submissions. I'll be guessing.
Yeah, me, I'm certain The proceedings didn't be. That's why, for instance, Section 337, you can quote the record of the regional court in the High Court. For instance, the bail application.
Yes.
When you argue bail application in the